SJC-11306, Commonwealth v. Joseph L. Bukin.
Good morning.
Good morning. May it please the court, I'm Jane Larman White. I appear today on behalf of the probationer Joseph Bukin. This is the appeal of a finding of violation made in January 2012. There was a sentence of 2 years, 6 months to serve balance, suspended for 2 years. 2 days after I filed a reply brief in this case, this court issued its decision in the case of Commonwealth versus Kelsey, which made explicit and clear that independent of federal constitutional guarantees of rights in this context, Articles 1, 10, and 12 of the Declaration of Rights provide similar rights, particularly the right to present a defense. Kelsey recognized as well that the process of prosecuting new criminal allegations via a charge of violations of the terms of probation allows the Commonwealth to obtain a new term of incarceration, quote, with relative ease, end quote. The burden of proof is lower. The accused will be afforded relatively few procedural rights. I would like to quote from footnote 10 of that opinion. To conclude that revocation hearings never implicate considerations similar to those implicated in the adjudication of guilt would be to ignore the close functional nexus that may exist between criminal trials and probation revocation proceedings. I'd ask the court to recognize as well that incarceration so readily obtained without the process afforded in the criminal trial context acts as a cudgel in the succeeding criminal prosecution. There's every incentive for the defendant to get concurrent time by just pleading guilty. And as this court decided in a case summer before last, Commonwealth versus Mylott, that would mean that none of the prosecutorial overreaching or deficits in process ever reach a court's attention. Here in this case, after the violation was found, some charges were dismissed on February 10th. That's at RA 23 in my brief. What is not in the brief, but I would suggest the court should take judicial notice of the docket in that case. All the rest of the charges were dismissed on August 16th of 2012.
But you're not suggesting that the Commonwealth can't proceed on a probation revocation. Your client has been sentenced to probation. That was his sentence, and there are strict terms of compliance, and the due process requirements for revoking conditional liberty under probation are very different than that in a criminal trial.
Well, I'm pointing out all of this that certainly you're right, but I'm pointing out in this case, and I'll enunciate about 6 reasons why Rule 6b-2 is important and not only is the law and should be followed, but that there's a reason for it. I don't disagree at all that there's a right to proceed against a probationer for violation of the terms. I'm talking about the process afforded him during that process.
Now, is it your view that Rule 6b-2 is constitutionally mandated?
No, it's mandated because it is a rule and has the force of law until it's repealed or amended.
And what do we do with the commentary and in Rule 1 of that, which says that those rules were designed to reflect existing law and were done as sort of the best interpretation of the Durling case at the time,
Which was 2000, I think.
which was in which we've since, under Negron, have clarified. Is it to be fixed in stone? Is it to, I mean, what happens when you have rules which are meant to present the existing law and the existing law changes?
Well, when the rule itself purports, and the commentary in Rule 1 says not only that it talked about existing law, but that there's a uniformity of procedure, and it sets forth a process to which probationers and the parties are entitled and should govern. I would forcefully argue that neither the appeals court nor this court is allowed to sub silentio rewrite those without actually writing them. The uniformity, if that's something that the court wants to do, and I want to talk about why the court should not do that, and this case brings up every reason why 6B2 is appropriate, there's an obligation to clarify the rule, to amend the rule. And I would hope that appropriate consultation with interested parties would occur in such amendment process. Here it was explicit that the criminal prosecutor acted to control the probation proceeding, overriding the probation officer's wishes for and steps taken to obtain live witnesses here at the hearing. He countermanded the lawful subpoenas of the probation officer, and there is record support for that. It was the probation officer's own desire to have that placed on record.
But your client didn't subpoena those witnesses. So how do you have standing to complain that
Well,
the Commonwealth interfered with the Commonwealth's calling of witnesses?
That brings me to what I would put in my second, as opposed to the first reason why 6B2 is necessary. The defendant has a right to present a defense at a probation revocation hearing, but under that formulation, he's entitled to present a defense only after he has presented the prosecution. And I suggest that that cannot be the right to which he's entitled in this circumstance. He could have subpoenaed the witnesses, but then again, they'd been subpoenaed twice and hadn't shown up at either time. But more importantly, the defendant, the probationer, is not obligated, in order to present a defense, to present the prosecution of himself on the probation violation. I'm sorry.
You go.
In this context, it should be recognized as well, if you imposed upon an accused that sort of burden, you would therefore obligate him, in order to defend against the probation violation proceedings, memorialized sworn testimony by which the Commonwealth could argue at the succeeding proceeding of trial could be used against him.
Well, there's a difference between saying you have any obligation to call a witness, but what you're arguing is that they interfered with your defense because they interfered with the probation calling a witness, and I don't and that's a peculiar argument.
What argument one talks about is that this was supposed to be run by the probation officer, and the probation officer and the Department of Probation has a coinciding interest with the probationer in a fair and thoughtful adjudication of the facts underlying. And so the probation officer was the one who wanted those witnesses present. And it was only because the prosecutor in the executive branch countermanded that
Well,
neither the
that's
probation...
a factual issue, right? That's your view of what the facts show. I mean, I do think there's...
Well, I'm sure the court has before it the actual language. This is in transcript volume 3, page 8. This is the probation officer. And this is after all the testimony is closed, and in context, it's the probation officer reporting to the court that he was distressed about the failure of the witnesses to appear, and even though the hearing is over, he wants it known, quite frankly. And I hate to put it this way, but they did speak with victim witness advocates in the DA's office, and they were each person, each victim relayed to probation that they were told by the district attorney. It turns out if the district attorney did not send them this summons, then they did not have to go. But summonses were sent out by probation.
But they also said they hadn't received them until the afternoon of the hearing.
Well, that concerns only the second summonses. In fact, in volume 1 of the transcript, you will see that the probation officer sent out summonses for the first hearing. And at that time, there was a lead time between December 6th and the initial hearing date of January 5th. The docket sheet records when those summonses were sent, and there was every reason, unlike the last one when the time frame was less, to know that they did receive them. In fact, if the witness hadn't received the summons, then they wouldn't have been able to tell the probation officer that they were told by the DA's office that they didn't have to come.
But I guess what I meant about that was an interpretation. It seemed, I mean, the suggestion that you make is that this was an intentional act by the district attorney to make sure those witnesses didn't attend this probation hearing. And it seemed to me that another interpretation, which is I think the one the Commonwealth advances, is that the victim witness advocate or whomever spoke to those witnesses wasn't aware that probation had sent out summonses to begin with. I mean, in other words, I'm not condoning it, but I just think it's, to the extent that you're suggesting that there was an intentional effort to not make sure these witnesses didn't get there. I just
Well,
didn't think that was.
Even if the victim witness advocate believed that the summonses were sent out by the probationer, did that person have the right to tell the witness, don't come, you don't have to come, if it was sent out by anybody other than the district attorney?
Well, I
So
wasn't
whether
sure.
or not the victim witness advocate believed she was talking about summonses sent out by probation office as opposed to the probationer, it really doesn't matter. That would directly implicate, more like the decision in Kelsey, which cited Bolero. You don't have to come unless the DA wants you to come. I would also suggest, as I pointed out in my brief and the reply brief, that this sort of procurement of unavailability is precisely the kind of finding that is normally done on hearsay evidence, because the witness is unavailable to actually come to court. It's the person to whom the witness has told the reasons for her absence. The Commonwealth brief at 44 posits that every allegation made to law enforcement is self-verifying. Simply because it was made, it's to be deemed reliable. This undoubtedly sets on its head anything one would know about both the criminal law and even the burden of proof in this kind of proceeding. I've already addressed, I believe, the obligation to prosecute oneself in order to have the right to present a defense. And for the reasons I've previously stated, I think that that cannot be the law. Third, we're talking about how informal, it doesn't have to comport with the rules of evidence, and it's a quick proceeding. But as recognized in Kelsey, there are certain situations in which the right to present a defense entails a right of discovery. In this case, as it turned out, when no witness was presented by the prosecution to elucidate the supposedly complaining witness's particular circumstances and perceptions, then there was not, since the defendant hadn't had discovery and didn't have the access to the records by which he could posit it himself, then it does implicate the right to present a defense as well. Not saying that there's an absolute right to discovery. It wasn't requested in this case, unlike in Kelsey. But I'm pointing out why what happened here points out the need for Rule 6b-2. Here, because the police officer opined that the alleged victim was competent and compelling, the judge needn't bother to make any appraisal himself. And this is in distinct contrast with cases cited in my brief, in which the prosecution has at least presented, for instance, a tape recording or a video recording of a sane interview, which would allow the judge to make an appraisal of the context of the allegations as well as the questioning and whether there were any leading sorts of circumstances. In sum, what occurred here is kind of what happened, and I realize that this is an entirely different area of the law, Commonwealth versus Odell in a grand jury presentation, where what occurred in the presentation was very misleading because of what was omitted. It distorted the import of the evidence. And the probationer suggests here that the particular deficits endemic to an Asperger's sort of diagnosis had a very definite impact on the circumstances and what occurred and whether there indeed was a violation of the terms of probation and new criminality.
And
So-
how would that have been different if Rule 6b-2 had been followed?
Well, if Rule 6b-2 had been followed, I would submit that the complaining witness himself, as well as if the witnesses had responded,
That would be Jameen?
Jameen, as well as his godmother and perhaps his mother, and these people were summoned by the probation officer to the first hearing date, and I assume for the second one, although they didn't receive them timely for the second one, that those people were the ones who had both the judge could have appraised Jameen and offered or asked questions, but certainly he would have been subject to appraisal on the stand. Also, as the defense attorney here tried to question the police officer, Poulin, about whether he had obtained any records from the godmother about the particular diagnosis or deficits and what ramifications those had, Poulin had no such knowledge. Presumably, the people more involved in Jameen's life and who had been summoned by the probation officer would have had both knowledge and access to the records. So here, I'm suggesting to the court that 6B2 only talks about a particular circumstance. It doesn't talk about all probation violation charges. It says only that when the only basis for the surrender is the allegation of new crimes, and when the only evidence posited about that is hearsay, there should be not only the substantially trustworthy and demonstrably reliable evidence, but there needs to be good cause as well.
Can I just interrupt you for a second here? Because it seems to me that the Commonwealth is maintaining that this was not a case where the sole evidence was the hearsay from the former, from the alleged victims, but that here that the police officer actually spoke on the phone with the defendant.
Yes, and I'm glad you brought that up. What he said, what the Commonwealth omits, and this is an Odell sort of premise as well, what the Commonwealth claims is that by reporting that conversation, he says that the defendant said, "I was only kidding." And therefore, the Commonwealth seeks to have that be corroboration of criminal allegations. But in fact, the police officer never told the defendant what the allegations were, and so there was no acknowledgement of any crime. And in fact, the Commonwealth then leaves out the defendant's second clause. This is all BS, or words to that effect. That could hardly be said to corroborate allegations of criminality. I see my time is up. Thank you.
Thank you.
May it please the court, Carolyn Burbine for the Commonwealth. Just to get to the last comment by my sister, the actual quote was, "I was just trying to make him fit in, and this is all BS." And that was after the police officer said to him that there were allegations that the adult victim had made about an incident involving the defendant and the adult victim.
Did the police officer ever tell him what those allegations were?
He didn't testify that he gave him the details. That was the
Just that
exact testimony.
allegations were
And
made?
Allegations had been made. But he told him that he wanted to talk to him in person for that reason. And it's our position that this record does not reflect that our office tried to commandeer this hearing. The record shows...
You mean the absence? Commandeer
I'm
the
sorry.
absence? Commandeer the absence
The
of
absence of these witnesses or the decision-making as to who would be called. I'd also like to point out, I'm not sure that...
But what does it mean to say to anybody, you don't have to go to court unless the DA summonses you?
Well, I think if we look at... well, first of all, we don't know when these conversations took place. We don't know the context. And so I don't think it's fair to just make assumptions that... and I don't think the record even shows that the personnel knew that probation or anyone else had sent, potentially anyone else had sent summonses.
But
The only note, if I could please, the only notation we had was that the advocate spoke to the mother of one of the victims on December 7th to explain the arraignment had taken place and what that entailed. And the advocate relayed the next court date. Now, I would think it's possible she said something to the effect, which is very close to what the probation officer said. She may have said something like, there'll be a lot of proceedings. If she's doing a general explanation of the court system, there'll be proceedings. Excuse me, you can come if you'd like. If not, you don't have to. But if we send you a summons, you'll have to appear. It could be something like that, not to the exclusion of anyone else.
You don't think a reasonable interpretation of the probation of, is it Horton? Is that the name?
Horton, yes.
Officer Horton's statement to the judge was that was that he wasn't referring to that conversation, that when he contacted these witnesses, I inferred that they had called precisely because they got the summonses. And
I'm sorry, Your Honor.
Well,
My impression is that he called them after they didn't appear for the second time. And the first thing that I want to make it very clear that his first representation to the court was that he had spoke to the adult victim's godmother and his mother. They didn't receive the summonses in the mail, so they didn't receive them at all. And then he spoke to the child victim's mother, and she said she just received it, and that's why she didn't come. And then he said, I hate to put it this way.
Isn't that for the second hearing, though, not for
That's
the
for the
first one?
second hearing, but
What
we-
about the first one?
He never made any representations as to why they didn't show up for the first one. All of this was
But there's no question that the probation officer had sent out summonses for the
that
first
he
one.
had sent out summonses. But again,
Oh,
like,
that summonses had been sent out
he
to
said
these
they
witnesses.
had, yes. he
All
said
right.
they had. So, but I don't think it's fair where we have no reference to dates or, what the context of the conversations were, just assume that someone in our office did this. Now, and I'm not saying that it would be defensible had they done that, but I'm not conceding at all that they did. I don't think this record establishes it. There's nothing to show that whatever this conversation was, that personnel knew that probation had sent summonses. We don't know the dates, we don't know the context. They've already had the primary reason they didn't show, it appears to me, is they didn't get these summonses, they didn't know about the date, they were not aware of it.
Well,
And
we-
then
I don't think
I
we're-
also,
I don't think we're going to be able to resolve this on the record here, but could you move to the question which we took the case about, which is what do we do with the rule?
I believe that the rule does not trump the case law, and the rule is very clear. We have the commentary that it says it's based almost exclusively on Commonwealth versus Durling. We have I'm sorry, lost my train of thought. We have the
Negron.
Negron, right, Negron and Nunez, and then in 2010 Foster, which all addressed, and Negron was the first one to address the ambiguity. It noted the ambiguity, so the court was very well aware of the ambiguity, what it entailed, and made a finding. So it's clear that the court considered the rule, what the rule said, what the import of the rule was, and decided.
So this rule has been in place since
2000.
2000.
Yes.
Is this rule followed every day in the district courts of our state, or is it ignored every day, or what can you tell us about that?
I have nothing on the record on that, Your Honor, and I don't practice in the district court, so I don't think I can give a fair assessment of that.
Is it your argument that Judge Dawley implicitly made the finding that was required under 6B2?
He actually specifically said in his ruling, if hearsay is deemed sufficiently reliable, good cause need not be proven separately, and I'm relying on Commonwealth versus King for that, and that's an appeals court case, which cites Negron and Nunez. So he specifically stated, and when the probation officer had brought up the allegation about what the victims had said, he had said that it was too late to bring that up. The evidence had closed, and he was just about to render his decision, and so it's clear that his ruling was based on King, Negron, Nunez, and that progeny.
And what would have made this hearsay relevant?
I'm sorry?
I'm sorry, what would have made this hearsay reliable here?
I'm sorry, I don't
The
understand.
hearsay on which the judge relied, why was it reliable?
Oh, why was
here?
it reliable? Well, you had, he based his decision on the fact that the two victims were interviewed separately by two separate police officers. There were at least 3 significant factors in their stories that matched. The defendant spoke of watching pornographic films depicting graphic sex scenes. The defendant engaged in the lap dance, rubbing and grinding his buttocks, and both victims said that the adult victim had tried to push him off. And he also found the defendant's admission that I was only trying to make him feel like he fit in also corroborated those allegations. And I would posit that that statement by the defendant is a statement by a party opponent, which is not hearsay and is presumptively reliable. And so 6B would not even apply under that situation. And then the judge also noted that he would have to look at factors such as whether the testimony is factually detailed, that he could look at the timing of it, which was, they spoke to the police the day after the incident. And it was based on personal knowledge and their direct observations, and for all those reasons, he found that it was substantially reliable, and I would posit that that is fully merited by the evidence presented.
The other evidence with regard to his statement, certainly standing alone, that does you no good at all.
But to get put together, it certainly
What does it corroborate? It corroborates that something
corroborates that-
occurred.
well, he doesn't deny that he-
that there was something going on, which he meant in good fun.
well, he doesn't deny that he was alone with the victim or that an incident took place, and that he didn't
Well, he
even.
didn't say the
well,
incident
I'm
took
sorry.
place, he just said, I just want to make him fit in, which said that there was some conduct that was designed to allow him, to make him feel that he fit in.
But he didn't claim that the adult misinterpreted his actions either. He just,
Well, but I mean, he wasn't told what the allegations were, so how can he have responded to them?
well, he was told there was an allegation about an incident involving the adult victim, and he didn't say what incident, I don't understand what you're talking about. Instead, he said, well, I just wanted to make him fit in. This is BS, which means he has a good idea what that incident must be. So I would say that is, the defendant certainly didn't deny that there was an incident at all, that he had been alone with the victims. So I do think it is corroborative that something happened. And I know my sister criticizes me, but I'm going to quote the case law in Nunez and Darling that says that while the judge, and I stated, while the judge didn't expressly find this, it is a criminal offense to make a false report of a crime to a police officer, and that can be considered in bolstering the credibility of the reports.
Okay, but that can't be sufficient by itself.
But it's still a factor that can be considered by this court and could have been considered by the judge as well at the hearing. Although he didn't, I'm not saying he made any such finding, but it is relevant case law, and it does bolster the credibility of the report in the Commonwealth's mind. Are there any further questions? I'm content to rest on my brief. Thank you.
Thank you. We'll take a brief recess.
All right.